Hello and welcome. My name is Ilda and I'm a partner in the immigration team at Kingsley Napley. Given that we left the European Union on the 31st of January and now are in a transition period that's expected to end at the end of December of 2020, effectively it means that British citizens travelling into Europe from the 1st of January of 2021 will be deemed as third country nationals. This now means that UK law firms who are now intending to send their lawyers, British national lawyers, to provide advice to their clients in Europe on a fly-in, fly-out basis, FIFO, will need to be thinking about the considerations from a practical perspective, not only on the visa side, but also on a regulatory side. With that in mind, I'm delighted to say that I have my colleague Marco Mazzeschi, a very well-renowned Italian immigration lawyer, and my colleague Julie Norris, a partner in our regulatory department, to talk to you today just a few issues about what you should be thinking as law firms if you are sending British lawyers on a FIFO basis to Italy. So with that in mind, the first thing I'm going to do is just ask Julie a few questions just from a regulatory perspective. So Julie, what would you say is the regulatory position for UK solicitors wishing to fly in, fly out of Italy post the 1st of January 2021?
Thank you very much, Ilda. Dealing with the narrow issue of fly in, fly out, law firms wanting to send their solicitors to Italy after Brexit, after the 1st of the 1st, 21, if there's no deal, I'm afraid is not completely clear. The starting point is this: the Italian Bar Association only regulates lawyers that advise on litigation. Everything else is unregulated. What flows from that is that reserved legal activity in Italy is confined to representation in court. Therefore, you need to be an EU lawyer or an Italian lawyer to represent clients in litigation or in court in Italy. Where does this leave UK solicitors? Well, we think it leaves them in a reasonably good position. They appear, or rather it appears, that they will be able to use their home country title, i.e. solicitor, fly into Italy, give advice on UK and international law, and fly out again. So foreign lawyers aren't regulated in the same way as they are in other jurisdictions. So this is good news, and the Law Society, who have been conducting a project with this in mind for a number of years, working out the position in respect of all of the EU 27 countries, are not aware of any enforcement action being taken in Italy. And so we're reasonably confident, subject to the immigration position, which Marco will tell us about, that solicitors will be able to fly in, fly out of Italy and give advice on international law and UK law.
Thank you. Will there be any conditions or restrictions attached to the scope of permitted practice?
Yes, two. The first I've touched on already is that UK solicitors must not fly into Italy and give advice in litigation, and they must not represent clients in court. Those are reserved legal activities. Italian and EU lawyers only can undertake those. And second, UK solicitors must not use the title avvocato. I'm sure I haven't pronounced that in the way that Marco would, but they must use their UK home title of solicitor. So those are the two restrictions.
Thank you. Will legal protective privilege apply?
It won't. This is a terribly important issue for UK solicitors flying into most of the UK 27 countries to bear in mind. It only applies to EU lawyers. Therefore, if you need your meetings or your conferences to be protected by legal professional privilege, you need to consider perhaps bringing in a local lawyer to ensure you have that protective wrapper. But no, Ilda, in short answer to your question, LPP will not apply.
Thank you, Julie. Marco, turning to the immigration position in Italy, what is the first thing I would ask is, do you have any top tips for UK law firms that need to send solicitors, lawyers into Italy after the transition period ends?
Thank you, Hilda. Thank you, Julie. Yes, for your comments. And in reality, the situation from the immigration point of view is different and more restrictive, because immigration laws in the Schengen area generally, they divide between business and work. So any non-EU nationals, like the Brits will be starting from January 1st, will be allowed to enter Italy on business for a period of 90 days, any 180 days, but on business only. If they enter for work, irrespective of the duration of their stay, in theory they should should obtain and enter with a work permit and a work visa. So the situation becomes very complicated.
Thank you. But assuming the British lawyer, the solicitor, is flying into Italy just to visit clients there, so the clients that are based there, they're not intending to give any advice. It's literally just if you like, a client care meeting. What is the maximum time that they can spend in Italy? I know you touched on the Schengen.
Yeah. It's important is a Schengen rule, it's not only an Italian rule. It means that the maximum period is 90 days, any 180-day period, but it includes any stays in the Schengen area, or any stays and for any purposes. Mm. Someone has spent weeks on a holiday in France or Spain, all the days will be calculated for the purpose of the 90 days. And the 90 days is a rolling period. It means that you cannot stay 90 days, just leave Schengen for 1 day and re-enter. They will look at the previous 6 months and calculate how the 90 days, how many days you have spent in all Schengen countries. And if I want to touch another very, very sensitive point, that until now, Schengen entry points, they don't have an electronic recording system. I mean, they scan your passport, but to check how long you have stayed, they have to check the stamps that they put on your passport each time that you enter or you exit Schengen. They are already implementing a system similar to the ESTA, the US ESTA, it's called ETIAS, that should be enforced by the end of 2021, that will connect all the entry points in the Schengen area. So it's very critical because until now we have not several, but some clients who are not non-visa nationals, Americans, Australian, they are not, especially in Italy or other countries, they don't check carefully their passports. So it often happens that it overstays and no one really make any trouble while they are leaving Italy. But from January 20 to 2022, this will be if the system is implemented and put in place, it will be automatically flagged if you overstay for 1 day. Mm. And secondly, another important point, the border police will be able to check how frequently you travel in and out in an area. So if you start to travel too frequently to Milan, someone may ask you, why are you traveling so often on business because you don't have a visa to Milan? Is business the real purpose of your trip, or if you are traveling regularly every week to Milan, is only for business, or what kind of activities you are doing while you are in Milan?
I think it's going to be difficult. In terms of if the solicitor, the lawyer flying out from the UK into Italy is going to do something that is effectively give advice, that's chargeable advice, even if it's for a few days, you have said that work permission is required. What does that work permission look like?
Yeah, work permission is not complicated, but it takes time. So we know we are lawyers, and sometimes a client asks you to join a meeting the same day or the day before. Until now, it was very easy. You jumped on the first flight and flying to Milan. This will no longer be possible because the processing time for securing a work permit, it takes 1 or 2 months to collect all the documents. And unfortunately, Italy, differently from very, very few, I have to say, other European countries, which they have short-term work permits for some kind of activities like firm crews or fashion models. Most of the other European countries, they don't have short-term work permits. So it means that if you go 1 week or 1 year, the processing time, the procedure for obtaining a work permit and visa is the same.
Thank you. So it's basically going to cause a lot of problems if you're not well prepared in advance, that you won't really be able to fly into Italy without securing the work permission and not knowing in advance.
Yes, and as a matter of fact, I'll tell you, in practical life, we see that for, again, what we call non-visa nationals, like the Brits will be. So anyone who can stay and enter Schengen without any visas for 90 days. American, Canadian, Australians, British citizens will be treated the same unless we find a settlement agreement. Controls on highly skilled workers, on executives, managers, are very, very unlikely to be practical. So generally, the inspection authorities, they look at illegal immigrants working at a site, a building site, in restaurants, these kind of activities. And so many people, often they think that, okay, and also another thing that to be taken into account, the definition of business and time is in Italy is very broad, like many other countries, 2 lines. So it's a gray area of what can be business or what is work. And we receive often from companies a long list, like an Excel table, say, can I do this, can I do that? They divide an activity in 35 different categories. But if you look at the Italy definition of business, business is business meeting, attending fair exhibitions, visiting a company, doing some kind of maintenance activities, and checking the functioning of things. Just to give you an example, some consulate refuse to issue business visa if it is for maintenance, because the word of the law is for checking the functioning of machinery. So it's a very critical, and it cannot be, when I talk to conferences, I say definition of business, like the discussion that was for centuries in Europe about what gender the angels have. You know, the theologians discuss for years or centuries which gender. The same applies for the definition. How can you define business? You know? And even EU regulations, there are some draft for changing some EU regulation for the blue card. They are trying to define business a little more clearly, but you will never have a real clarity, because each country wants to maintain discretion and power to define what is business and what is work.
Thank you, Marco. I suppose then that the question that I have, and it's the last one, is what do we do then if all else fails? We can't get the work permission. These flights are, business trips, as you say, could be at a moment's notice. What should we be doing if all else fails?
First, hope that there is a settlement agreement. Secondly, I think that the same situation will apply in most European countries. The only solution that I foresee is like a lobbying pressure on the European Commission to give some guidelines to the countries and to introduce short-term work permits, or to include legal advice, or let's say, yes, legal advice non-connected to litigation, as Julie was mentioning, in a kind of activity which can be carried out for short-term periods, like 1 week or 2 weeks, without need of securing a visa or a work permit. But at least in Italy, very often you have a contradiction between what is the Ministry of Foreign Affairs is saying and the Ministry of Labor or the Labor Inspectorate is saying. To give you an example, we have the same issue with fashion models and film crews. The Ministry of Foreign Affairs was stating in writing to us that they could enter Italy on business up to 90 days. And the Ministry of Labor came out very clearly saying, no way, they can enter on business if the activity is preparing a site location, casting for fashion models. If they enter for a paid activity, even for 1 day, they should enter with a work visa.
Thank you. That's a lot to take in, but I'm really grateful, and I hope that everyone that will be listening to this podcast will have some takeaways, just in terms of what they should be thinking, what they should be planning ahead. And it will be interesting to see if there is a deal, how that would look and what that would mean for law firms going and the services that they provide into Europe.